Looks like we're good to go. Is everybody here and ready?
We're ready.
Wonderful. Good morning. You are attending the meeting of the Citizens Clean Elections Commission. Hope everybody's doing well this morning. I'm having trouble waking up. I probably needed more coffee. I don't know what's going on, but the first item on the agenda today is the call to order. It is 9:30 on October 29th, 2021. So I will go ahead and call the meeting to order. I'd like to ask the audience members to please keep their microphones on mute. And with that, we will take attendance. Commissioners, could you please identify yourselves for the record? Perhaps we can start with Commissioner Kimball.
Commissioner Kimball is present.
Thank you. Commissioner Payton, can you identify yourself?
Commissioner Payton is here.
All right, and I'm Commissioner Chan. I am here also. We have a quorum for business today, and with that, we can move on to agenda item 2. Bear with me one moment. Okay. Discussion and possible action on the commission minutes for July 29th, 2021. Is there any discussion? And if not, do I have a motion to approve the minutes?
Madam Chair,
Yes, Commissioner Kimball.
I move we approve the minutes for the commission meeting of July 29th, 2021.
Thank you. Do I have a second? Oh, I think Commissioner Payton, you're on mute. We'll give you.
And I would second that.
Thank you. All right. We have a motion and a second. Let's go ahead and call the roll. Commissioner Kimball, how do you vote?
Commissioner Kimball votes aye.
Commissioner Payton?
I vote aye.
And I vote aye as well. So by a vote of 3 ayes and 0 nays, we have approved the minutes as written. And we can move on to agenda item 10, discussion and possible action on executive director's report, enforcement and regulatory updates, and legislative update. Tom?
Yes, thank you, Madam Chair and Commissioners. I know it's been a little while since we've met. As you can see, we have, well, first I want to note a couple of things. One, November 2nd is the local consolidated election day, or is the consolidated election date for the local elections happening. As we speak, we've had we have details of those election sites on our the elections in the various counties and jurisdictional subdivisions like school districts on our website. I just want to give Gina and Alec and Avery credit for putting that together. And if I missed anybody, it's been well received. We know that it's been distributed to folks through a variety of channels just as a guide. And I have an anecdotal, an important reference from my mom, which was the fact that she figured out where to drop her ballot for the school board election, the school district election, I should say, based on our website, which she got to on her own. So this is all very good, and we're very happy about that. Also, Chairwoman Chan and Julian Arndt both have completed election officer certification training with the Secretary of State's office. So congratulations to them, and I think their certificate will arrive at some point. We don't control the certificate, obviously.
I still have to do research, actually.
Oh, you still do research. Well, anticipatory congratulations. As the report notes, there's been a full panoply of voter education activities over the last several months. A couple of things that I think are key. Commissioner Titla, Gina and Avery participated in a tribal conference that Secretary of State Hobbs put on, and Gina was a participant in a panel discussion there. Both Gina and Avery have kept up a full organizational, I should say, educational role, and been called in to discuss with a variety of different groups what Clean Elections does, and particularly what we have to offer from an educational perspective. We did launch our civics curriculum during Civics Week, which was in September. That's housed on our website. We have a storytelling project that we did with that. So Chairwoman Chan, Secretary Hobbs, other folks from around the valley and state, did a storytelling project about people and their influence and/or their experience with voting. We're very excited about that. Again, anecdotally, I can tell you that I mean, I've heard from a friend of mine who's a teacher, the government teacher at their high school is using our curriculum. So we're getting, and we've been, I think the Department of Education has been, and the heads of the Civics Education Consortium there have been very helpful. I'd invite Avery to interrupt me here if there's anything I'm missing as far as fleshing out some of that curriculum issue. I don't know if I want to, not issue, but if there's anything I'm missing, Avery, I'd interrupt me or. So we're very excited about that continued partnership, and so. I also wanted to mention, and I think it's important, Lilia Monares, who's been our core reporter for the past, a long time. This is going to be her last meeting as our core reporter, so I just wanted to thank her. I know Paula and I certainly wouldn't be able to do our jobs without having Lilia's services and her efficiency and her skill. So we're grateful for that. And I think that probably will. I think that probably sums up the highlights. I think. And if you have any questions, commissioners, Chairwoman Chan, commissioners, I'm well open to them.
Thank you.
Madam Chair,
Yes, Commissioner Kimball.
Tom and/or Avery, I see a mention in here about meeting with One Arizona to discuss Arizona redistricting. Obviously, we don't have any official role in the redistricting process, but can you talk a little bit about what we are doing, if anything?
I might start, I guess, or Avery, do you want to go first? I didn't hear anyone.
Yes, Madam Chair, Commissioners. Yeah, well, we kind of, as far as the One Arizona and redistricting, we have been teaming up with their outreach team and sharing information. I know we had a few meetings, at least 3 or 4 meetings with them, and I basically gave them a lot of my contacts for outreach so they can go to the community level, grassroots, and inform those people about the process. So it's kind of been an information sharing partnership. So they share information with us, and then we will put it on our website, and then we will inform them about things we know, maybe about different organizations, or put them in contact with people who they should speak with.
That's amazing and wonderful. Thank you for doing that. I actually was so impressed, Tom, with the list of what Avery and Gina have been working on, and was also just reminded, hearing from Avery, congratulations, I think are in order. You're a published author now, right?
Oh, wow.
Thank you.
Yeah. Tom, did you want to add anything?
Oh, no. We're pleased. I think that that the AIRC folks have reached out to, especially to Avery and Gina, and no, that's about all.
Okay, Commissioner Kimball, did you have any additional questions about that or comments?
No, I did not. Thank you.
Okay.
Thank you.
Anything else? Anything further on item 3 before we move on? And I think we're going to hold item 4 for the day.
Yes, please, Madam
Okay.
Chair.
Thanks, Tom. And moving on then to item 5. Just one moment. Okay. Discussion and possible action on MUR 2101, the power of fives. This is an enforcement related item, and since we're meeting virtually, I'll have Tom introduce the item and give an overview of his recommendation, and then have time for commission questions. And following that, I know Tim Lasota is here, and then we'll hear from him after Tom presents and we ask him questions. After that, we'll allow Mr. Lasota to speak to us, the attorney for the power of fives. And so we'll begin with Tom.
And just, sorry,
Go
Madam
ahead.
Chair,
Yes.
apologize to interrupt. I just want to make it clear that for this item in particular, Monique Cody, should the commission have any questions, legal questions, and need to go into executive session, I just want to make it clear on the record that because Kyle and I are working with Tom to do the investigations, we will not be participating. It'll be Monique Cody that you will be asking your questions to, and we should not be involved in the executive session as well. So I just wanted to get that out on the record before the presentation started. My apologies for the interruption.
Oh, you're very welcome to interrupt, especially when it's something important like that. I mean, anytime, everything's important. So thank you so much. And thank you so much for being here, Ms. Cody.
You're very welcome.
Madam Chair, just by way of background, in about a year ago, a little more than a year ago, the commission received a complaint from Dr. Bob Branch, who's the managing member of a limited liability company called the Power Fives, against a participating candidate named Eric Sloan. The commission found reason to believe, based on that complaint, in I believe December of 2020 or January of 2021. In April, the commission met again, and we the commission, I should say, ordered Mr. Sloan to repay monies that the Clean Elections Fund had paid out to him, and he did so. We then, in late September, I filed under our rules a complaint that against the Power Fives, because as explained in the complaint and the reason to believe memo, we believe there's reason to believe that a violation may have occurred with respect to the Power Fives conduct in the 2020 election. So for purposes of this discussion, this is about the Power of Fives actions, and so that's what we are focused on today. I think that obviously this is a matter that has some complication to it. It's not necessarily a simple issue. I think, however, that there's really a few facts that are not in any serious dispute that are the critical facts for a determination of reason to believe. Now, a determination for reason to believe, in the staff's view, is based on, whether or not a violation of the Act or rules may have occurred. The facts that we think are, or I should say, I think are dispositive of a determination of reason to believe are: what is the Power Fives and what did it do? The Power Fives is a limited liability company. The Power of Fives was formed for the express purpose of identifying and supporting candidates for public office in Arizona. The elements of being a political committee under Arizona law are that you were formed for the purpose of of influencing elections. As I just articulated the purpose of Power Fives, we think that's not subject to debate. We know that the commission, that TPOF, under the service agreement that they joined with Sloan, was providing services to Sloan, despite the fact that Sloan did not have cash on hand at the time. And we know that the Power Fives made no reports of its own. There's no exemption under the Clean Elections Act for an entity that is considers itself a consultant when that entity admits that its purpose is the support of candidates. It refers to its candidates as partners. These are all indicia. If there was any question, this is a political committee operating under a nominally different name. I mean, literally a different name, just with no other distinguishing characteristics. Because that's true, I mean, in our view, once you make that determination, it becomes incumbent on that organization to have filed reports that were not filed. It's not incumbent on the commission or on the staff at this point to determine how those reports should have been filed, because the absence of filings means the accounting that would have been done hasn't been done. So in order for us to move past the reason to believe stage and get to a probable cause to believe stage, we're requesting your authorization to proceed with an investigation. Thank you, Madam Chair, if I went long, but
No, it's okay. I was interrupting you a little bit because one of the biggest questions I think I have is, my fear that, how is this distinguishable from, and I know other consultants and agencies that do this type of work aren't before us, but is this distinguishable from the work that other consultants do, for example? I just feel like.
Sure, that's a fair question.
Look at the letter of the law, but I just am curious if they operate in a different way that distinguishes them from other consultant type businesses.
So, Madam Chair, Commissioners, a very fair question. And the issue in this case is, I mean, quite honestly, I don't know the answer to your question. I don't know what the industry practice is. I hope the industry practice is not the service agreement here, because the crux of this complaint is that the service agreement that the candidate Sloan and TPOF entered into stated expressly that services would be provided for phase 1 and phase 2. Payment for phase 1 and phase 2 would not arrive until the person received their money from the Clean Elections Fund if they qualified. Therefore, any services provided, and we know it's up to $116,000, were forwarded, were advanced, were loaned. And to the best of my knowledge, most political consultants are not in the business of written finance agreements with their candidates to carry them to qualification. If it were so, the very essence of the Clean Elections Act would be undermined, as well as other issues such as corporate contributions. So there are so this service agreement distinguishes which came through the complaint in the first place, is what distinguishes this case from other cases that we've dealt with.
Well, and to me, I just wonder if those are two separate issues. And that's why I'm asking about the Political Action Committee piece, because when I saw the original complaint from Dr. Branch about candidate Sloan, my initial thought was, you can't contract for services. I mean, contracting for services is an expenditure. And therefore, I felt like that was a pretty clear-cut violation of our rules, for example. And I remember way back years ago, a decade or more, maybe, Janet Napolitano in her governor's race got in trouble for that exact thing. But isn't that separate from whether this consultant needs to register as a political committee? I don't know that I see them as intertwined, and that,
Sure.
I guess, and if you want to address it, great, and maybe Tim Lasota may have some, I mean, I know he has,
Yeah.
oh, he's going to address it. He addressed it
Sure.
in his answer, but if you want to try to address that, that would be great.
Sure. I'm Madam Chair, Commissioners. I think that the key here is that they are separate. In other words, there are actions that Mr. Sloan took, and we've talked about those. And there are actions that the Power Fives took. The reason why the service agreement here is so, at least we see, critical to the issue is because it literally sets forth the payment terms and sets them at a level that was inherently above the cash on hand that would have been available to that candidate up to the disbursement of primary funds. And the service agreement distinguishes between the primary funds and the general funds and says that the general funds will get paid for from the allotment that comes in going forward. So in essence, the upshot of what the service agreement did was say, by the distinction between the general and primary election, was say, we're going to front you the primary and you're going to pay us cash on hand for the general because we know you're going to get the general grant up front at the beginning of the general period. So it's that distinction within the contract, in addition, that demonstrates that this is that the agreement was for TPOF to carry Sloan to qualification, and Sloan was to pay them at that time. There's no evidence that Sloan ever had $116,000 on hand when the agreement was signed, and in fact, he couldn't have, as a matter of law.
Thank you. Do the other commissioners have any questions for Tom?
Madam Chair.
Yes, Mr. Kimball.
Tom, let me ask again about that last point you just made. So in his letter, Mr. Lasota's point was that there were numerous escape periods during the primary. Like if he didn't qualify as a clean elections candidate, then he could end the contract and wouldn't owe anything. Does that, at what point does a contract become a contract if you can, and I guess this is a legal question, if you can back out of it with no penalty, is it still a binding contract from the point that you first signed it?
Madam Chair, Commissioner Kimball. Well, I can on the merits of that question in terms of what the advocacy, our point or the staff is on the of the contract is this: the fact that let me put it this way, there are contracts that have clauses in them that waive repayment. Under campaign finance rules, if you're financing something with cash on hand, the fact, if it were forgiven, it would become a loan, right? So those clauses that the response discusses are the clauses that in fact confirm that this was financing. Because if the person didn't qualify for the ballot, the loss was going to be borne by the Power of Fives, not by the candidate. As soon as the Power of Fives, therefore, became essentially the guarantor of services through the primary, it was the financier of the primary election activities.
Okay, thank you.
Commissioner.
Commissioner Kimball, would you like me to provide a legal response regarding your question on the validity of the contract?
Yes, I would appreciate that.
Sure. So once a contract has been executed, being signed by both parties, it is legally enforceable. And although the terms might seem confusing in certain contracts, it is legally binding. In this particular contract, there are other clauses in there as well, such as the termination clauses. There's timing involved with, I believe, all of them other than mutual termination. There's clauses in there regarding payment terms, but it is a legally binding contract, and you would need to look at it in its entirety, which I'm sure you already have done, but it is absolutely binding once executed. Does that answer your question, Commissioner Kimball?
Yes, it does. Thank you, Ms. Cody.
Thank you. Okay, so at this time, Mr. Lasota, I will give you the floor to present your response, and if we have questions, we can ask them of you afterward.
Thank you, Madam Chair and members of the commission. I'm Timothy Lasota here on behalf of the Power of Fives this morning, and I think that the commission wisely focused on a couple of questions that Mr. Collins still has not answered. I think this is a very bad precedent. What Mr. Collins wants to do, the Power of Fives is a vendor. I put it in my letter. You know, if they're a vendor, then I don't know, and now they're a political committee. They got to do all these reports. I don't know why I wouldn't have to do the report. He also didn't really answer the question of he doesn't know how other campaigns are run or how other vendors handle things. Well, you know, the bottom line is this is just the way it works in this realm. I mean, vendors provide services and they're paid or not paid. I mean, I'll just give you one example. What if a vendor happens to not be paid by a candidate? I think under Mr. Collins' logic, now that vendor is a political committee because they've made an in-kind contribution to the candidate. It doesn't make sense, and there's no end to it. It's a very significant regulatory leap. Now, in terms of the contract, whether it's in a binding contract at the outset, I don't think is at all the question that the commission should be focusing on. I think the issue here is, you know, Mr. Collins wants to call this financing. He wants to call it a loan. I mean, a loan is here, I'm going to give you money and you have to repay it. Well, as the arbitrator in a related civil suit found with regard to this arrangement, it wasn't a loan at all. A loan is something that you have to repay. And I'd like to quote briefly from the award, the arbitration decision. It was made by Rebecca Albrecht, who's a highly respected former Maricopa County Superior Court judge. It said the agreement did not bind the campaign to a specific obligation. There was no debt created for the campaign by entering into the agreement. Yeah, agreement's valid, but there's no debt created by entering into the agreement. There was no obligation to pay until/if Sloan qualified for public financing. There is nothing in the clean election laws and regulations that prevent a candidate from entering into a contract for services before he receives clean election funding with the payment to be paid upon receipt of clean election funding. That's the issue right there. So I think that, you know, there's just not a lot to say that I haven't said already in my letter, because Mr. Collins, you know, his response or the statement of reasons of the executive director, it was just a regurgitation of what he did the first time, and he didn't address any of the points I made hardly. He still won't acknowledge Arizona Advocacy Network and its finding about what the regulatory authority of the commission is vis-a-vis the Secretary of State. In fairness, that case did find certain regulatory authority, but it said it's largely limited to Article 2 or things in Article 1 that impact Article 2. One last thing I'll point out is, well, actually, I did want to mention that, and this is a minor point, I know, but it just goes to show that that Mr. Collins he's got no real answer. He didn't answer the commission's questions really when they were asked. But this business about the email that Mr. Branch sent being illegal. So here's what the statute says. The statute says to be a qualifying contribution, it's got to be $5. It's got to be this, that, and the other thing, and it can't be sent by an agent of the campaign. Well, okay, so it's under that statute. It's either a qualifying contribution or it's not. At worst, it's not a qualifying contribution. The statute doesn't say it's illegal to send the email. It says, at worst, it says if you send this email, this is not a qualifying contribution. It doesn't say it's a class 1 misdemeanor. It doesn't say it's a civil violation. It simply says that if this comes from an agent of the campaign who's being paid, it's not a qualifying contribution. That's the only remedy. And that leads me to my last point, which is, if you just look through the whole fabric of the Clean Elections Act, you just so what's the remedy against a vendor? I mean, I pointed that out in my letter that there's no real remedies. I mean, you've got fines you can impose against candidates, but if you look through 16-941 to 43, I think you don't come up with anything this commission can do about vendors. So I think that tells you, there's a reason there's no penalty, and that's because the act was never meant to get into these situations. I didn't see anything from Mr. Collins about that point either. So that's probably the most telling thing is, look, if this were something that the drafters, the people when they passed it really wanted to get at, you'd think they would put something in there that, if you send one of these emails and it comes from an agent, what's the penalty? Well, the penalty in that case is it's not a qualifying contribution. What's the penalty for any of this other thing that Mr. Collins thinks is subject to regulation? It doesn't say. I mean, the Act's penalties are directed at candidates because that is supposed to be the sort of the realm of enforcement of the commission. And I'd be happy to try to answer questions.
Thank you, Mr. Lasota. Do any of the commissioners have questions?
Madam Chair.
Yes, Commissioner Kimball.
Ms. Lasota, going back to the question of the contract, you said that no debt was created by the campaign. Okay, but I think the point here is that no debt was created by the campaign, but a service was provided by the power of fives, and it was not paid for until something would happen in the future, and it may or may not happen. So it's not so much that there was no debt created by the campaign. It seems like there was a service that was provided on the hope that the power of fives would be reimbursed, which Mr. Collins has characterized as a loan. Could you address that?
Certainly, Madam Chair and Commissioner Kimball. So a loan is, I know Mr. Collins says that that's a loan. A loan is something that you have to pay back. That's the definition of a loan, and it's I'm giving you money and you've got to pay it back. And I, not to belabor the point too much, but I'll just quote the arbitrator. The agreement did not bind the campaign to a specific obligation. There was no debt created for the campaign by entering into the agreement. The obligation to pay did not arise until if Sloan qualified for funding. Under those circumstances, that is not a loan. That is something else, but it is not a loan. I mean, this is a disinterested arbitrator that made this finding because the argument was made that the contract is illegal, so it wouldn't be enforced. So it shouldn't be enforced. Well, the arbitrator said, no, the contract is legal. And it's just not a loan when there's no obligation at that time to pay it back.
Well, Madam Chair, Mr. Lasota, you provided the powers of fives provided some services before they were paid for. Certainly the power of fives, it costs them something to provide these services, whether they were paid for them or not. The powers of five was out some amount of money for providing the services that were provided before they were paid for. Am I right?
Mr. or Madam Chair and Commissioner Kimball, yes, and I don't know the exact timetable, but this is it again. I think that focuses on the wrong inquiry, because I think the question is this a loan? And I think clearly it's not a loan, because maybe there's a hope that the qualification will happen, maybe, but a hope is not a binding obligation to pay, which is what a loan requires. Something that, well, if this happens and that happens, then you'll pay me from your proceeds. That's just not a loan. I mean, the other thing, and I should have said this at the beginning, it's a little surprising that the way Mr. Collins, this is a very innovative way to help candidates. Clean elections funding has certain advantages, but it has certain difficulties. This is a very innovative way of getting more people into the system. I would think Mr. Collins would be supportive of it, because it's legal, and it's a way of helping people participate in this system and overcoming some of the inherent challenges of clean elections funding. I know that wasn't responsive, but I should have said that at the beginning. Hopefully I've answered your question. It's just not a loan, as the arbitrator found.
Thank you.
Thank you. Listening to the conversation about the loan versus not a loan, it in the terms of, I'm not a contract expert, but in the context of the contract, it just sounds like the Power of Fives was willing to take on the risk of helping this candidate get their $5 qualifying contributions, thinking we can help them qualify and therefore then we'll get paid, which again, I think is established on the candidate side, that they can't contract for things without, pay for things like that before the funding. And I hope I'm not misstating that. Mr. Lasota, if you want to respond to that, you can, but I think that's well settled.
I think that's exactly right. And as an attorney, I sometimes, I've sometimes done that myself, that, look, you could pay me at the end, if you like what we, in unique cases, but I've certainly done it. And, look, you can pay me at the end and pay me what you think is right, if we've achieved something that you think is good. But, if you don't pay me, you're not going to get so much as a nasty email from me, much less a lawsuit for breach of contract.
Okay,
But
good.
that's a risk I accept, and it's. I think that's the distinction here. It's as Chairwoman Chan said.
Okay, thank you. And to me, again, I just want to make sure I kind of understand where both Tom and Tim are. So Tom, it sounds like the argument from your legal position is that by virtue of the violation, okay, by contracting into kind of a violation, a clean election violation, that puts the LLC in a somewhat different position, maybe? The virtue of the violation kind of puts them in this position?
Tom, you're
I'm
muted.
sorry.
Madam Chair, Commissioners, I wouldn't say that's not precisely our position. Our position starts at the beginning of the Power of Fives, not at the beginning of Eric Sloan's campaign. The Power of Fives was formed expressly to identify and support candidates for office. That is the exact type of activity that constitutes influencing the results of an election. There's no equivocation by the Power of Fives about why it was formed. So that's checkbox 1 on the road to being a political committee. Eric Sloan doesn't even have to be there.
Okay.
Checkbox 2 is, did they accept or expend more than about $1,000? I don't think there's a serious dispute about that. I don't think that we know the precise amount, and I don't expect Mr. Lasota to know that. The point is, it's unreasonable based on what we know occurred here to believe that they were somehow all accomplished for less than $1,000. Because we also know there's 22 other candidates out there who may or may not. How far they got, we don't know, but we know that they were involved in the same thing. So that takes care of the expenditure piece. They're not a nonprofit. That takes care of the exemption piece. Once you're in that bucket, you got to file. The reason Mr. Lasota's law firm would not be a political committee is because Mr. Lasota's law firm is created for the purpose of providing legal services. That's a distinction with a big difference. I mean, relatedly, the contract terms that Judge Albrecht was looking at was under an argument that said that the entire contract was void. Our argument isn't that the contract is void. Our argument is that entering into a contract that calls for you to pay more than you have on hand at the time in the future is a clear violation of the Clean Elections rules. But the activities of TPOF go far beyond that. And so accounting for those is triggered by the purpose and spending. I think the one other, if I can, just just to get through a couple of things, I agree with Mr. Lasota. I don't know what the industry practice is. If the industry practice involves this kind of contract, that's an issue that we need to do some education upon, quite honestly. The comparison of a commercial loan case to campaign finance, they're not analogous because the definition of contribution is loan, advance, deposit, etc. So it doesn't have to be a loan for money. It has to be something else. And then so I guess finally I'll just say our logic is not that Mr. Sloan could turn the Power Fives into a political committee, but the reverse. The Power Fives was a political committee that went out and sought candidates.
Okay, thank you, Tom, for clarifying. That's helpful and illuminating. Mr. Lasota, did you wish to speak?
Yes. So the Power of Fives was formed to make money. Mr. Collins saying it's formed as a political committee is just not true. It was formed for the same reason my law firm was formed, to make money. That's the purpose. Campaigns are formed to win elections. I think that's the critical point. The one other thing, just one other real quick, is that, Mr. Collins is arguing that this contract is void because if it's illegal, if what he says is true, then it's for an illegal purpose and it would be void. So, I don't even know that that's terribly relevant, but just as a point of clarification, he's wrong about that. So, and that was precisely the argument that failed in front of Judge Albrecht. And that's all I have. Thank you.
I see Kara has her hand raised, and I'm sorry if I missed that, Kara, earlier.
Yeah. Now I'm wondering if I should even, because you guys kind of hit on some of the things, but there was a question, Chairman, Commissioners, from, I'm sorry, it's been a while at this point, but I want to say Commissioner Kimball, asking about the expenses being incurred. And we know, according to Dr. Branch's own complaint to this commission against Mr. Sloan, that, and I quote, "The Power of Five LLC's expenditures for Sloan began in September of 2019, when Mr. Sloan requested the Power of Five start buying nomination petition signatures." So the Power of Fives was out in the field spending actual money to purchase signatures for candidates. And this was before the contract was even signed. You don't see that anywhere. You don't even see that in the invoice that the Power Fives eventually sent Sloan. And the rules specifically state that a candidate or campaign shall be deemed to have made an expenditure as of the date upon which a candidate or campaign promises, agrees, contracts, or otherwise incurs an obligation to pay for goods or services. Now, the contract, while they argue that no money is due until a candidate qualifies for funding, again, there's an issue in terms of how do you how that exceeds cash on hand if you've got expenses going out the door before a candidate qualifies for funding. And you have a question about the single bank account because most places don't let you open a bank account with $0. But in paragraph 2 of the Power Five service agreement, which they, not only used with Mr. Sloan, but have used with all their other, but they've admitted they use the exact same contract with other candidates, and they're doing so again this cycle. It says that for services provided in phase 1, the company shall submit to the candidate not later than 10 days following the date hereof an invoice setting forth the payment owed for phase 1. The candidate shall pay all undisputed amounts on such invoice within 30 days of the earlier of the termination of this agreement, or once the candidate qualifies for public financing for the primary election. That language, I believe, could be read to say that those signatures that we collected for you in September and paid money for, here's the receipt. This is what you owe. Pay us for these, even if you didn't actually qualify for funding. So I don't know that, they're trying to argue that this contract is a purely contingency contract. And I don't know if that's true. And even if that were true, that would only cover phase 1. Phase 2 and phase 3, you still owe 100%, and that money doesn't have to be paid right away. Therefore, the reporting doesn't occur right away. So I think that really, regardless of how this shakes out, I mean, like Tom said, it's complicated. There's a lot of moving parts, but we've tried to look at it a number of different ways. And it just, no matter how you look at it, I don't think that there's a way to escape the fact that this has created a black hole that, you can sign this contract and really just prevent the disclosure of any of these contributions and or expenditures until later in the cycle. Because how are you supposed to know that, the Power Fives was paying someone in September of 2019? Under Mr. Lasota's argument, the Power Fives could pay someone in September of 2019 to purchase signatures on behalf of Mr. Sloan. And if Mr. Sloan never qualified, that would never be reported.
Why isn't it Mr. Sloan's responsibility to report it?
Well, because Mr. Sloan never incurred
The
an
cost.
expense at that point.
Okay, I see what you're saying. Okay, thank you. And I'm sorry I interrupted there at the end, perhaps. Did you-
No, it's fine. I had nothing.
Okay. Commissioner Kimball, Commissioner Payton, any other questions? Okay, and I don't know if, do we have anyone else who would like to comment about this matter before we, and I don't know if,
I would like to. This is Eric Sloan.
okay, sure. Mr. Sloan, please go ahead.
Well, I've been very interested by the conversation that's being had here. Let me first start by saying that I'm having to represent myself in a civil matter where Bob Branch and the Power Fives has personally sued my wife and I for the entirety of the $116,000 that was requested payment in the contract. Let me also point out to the commissioners that that is that a arbitrator decided that there were four corners to the contract, and that she also stated in her opinion that the only feasible objection to the contract would be that there could be a potentiality that it does not comply with an elections law. And let me point out that the arbitrator said that it didn't bind the campaign to specific obligation and no debt was created by the campaign entering agreement. But that ruling is in direct opposition to Clean Elections Law Administrative Code R220-110 B5, which states, for the purpose of the act, the commission rules a candidate or campaign shall be deemed to have an expenditure as of the date upon the candidate or campaign promises, agrees, contracts, or otherwise incurs an obligation to pay for goods or services. You know, her point that there's nothing that prevents a candidate from entering into a contract before they receive funding seems to be in direct contradiction to your previous repayment order, where I was asked to repay $94,000, which I did within 24 hours because that money had been set aside and not spent in my primary election because there was a conflict with regards to if the contract was actually a valid contract. My argument has been consistent that this contract is not valid because the very enactment of the contract was a violation of the Clean Elections Law. I am now being put in a position in a civil matter where I'm being told I have to break the law and pay Dr. Branch and the Power of Fives. Again, and then on the other end, I've been told by Clean Elections that, when you enter into an agreement, that agreement becomes the equivalent of a debt, right? I think that we're really at a point now where we need to decide whether or not this contract was valid or not valid, considering that, and I did not understand this at the time of signing the contract. Let me be very clear. I relied on Dr. Branch in the Power of Fives, who presented themselves as experts in clean elections law. In fact, the very nature of his company's name would give you a reasonable expectation that he was an expert in clean elections law. As it turns out, he was not. There were some other things that happened during the campaign, which led me to believe that Dr. Branch was running what was the equivalent of a fraud, because he was promising things that were never coming to fruition. I would also point out that in this position that I'm in, I'm asking, I would be asking the commission to make a determination whether or not this contract was legal and enforceable, because that will have a direct bearing on not only my case, but other cases that Bob Branch is pursuing. There was another candidate, Jackie Fox, who did not qualify for clean elections, but was sent a demand letter for over $10,000. And I believe Mr. Lasota wrote that demand letter. And so the question becomes, that the Power of Fives wants it both ways. They want you to tell them that they can continue to do business in direct violation of the rules that are explicitly written. And they want me to pay them out of my own pocket, and they want to go after other candidates. It is a predatory practice, and I'm hoping that this commission will take a stance on it.
Okay.
That is all. Thank you.
Thank you, Mr. Sloan. And these situations are always difficult. And I know, especially when parties to a contract have had significant legal issues in this case, I know. And so I appreciate you both, Mr. Sloan and Mr. Lasota being here to speak to this. I know some of the things, I personally believe that when it comes to election law, contract law can maybe be informative. It may not be the be all end all of how we analyze it. I'm getting some noise from somebody. I don't know. Is everybody on mute or that's okay? I think I don't know who it is, but anyway, it was coming through when Mr. Sloan was speaking too, but I think it can be informative, but perhaps there are different legal standards that can apply in different legal scenarios. So contract law is different from election law, et cetera, but it is informative. And I guess at this point, do the commissioners have any further questions? I don't know if we need to speak with Ms. Cody. What do you think, Commissioner Payton?
Yes, this is Commissioner Payton. I think we should go into executive session.
That's kind of how I'm feeling, frankly, as well. If Ms. Cody wouldn't mind doing that with us, just because I feel like I have some more legal questions that I need to discuss still. So Ms. Cody, would that be acceptable if a motion is made?
Yes, that would be fine. But if there's a separate line, I would need to be informed of how I could join you in executive session.
I think that the moderator can take care of that. Ms. Herring?
Yes, so I will open a breakout room and only invite those who should participate in the executive session to enter the breakout room. There will be no time limit, so you can stay in the executive session as long as needed. The remaining participants will stay in this meeting room, and then you can return to this meeting room at any time.
Okay, and how is our court reporter doing? We've been in meeting for about an hour. Do we need to take a quick break before we make these motions to go into executive session? Or how are we doing? Court reporters?
Yes, I'm sorry.
No, it's okay. I sprung that on
Off of mute, but I'm fine with proceeding. Thank you.
you. Okay.
Commissioner Chan?
Oh, yes, Kara.
Just to be clear, it'll be only the commission members and Ms. Cody who will be in the executive session, or who should be invited to the breakout room.
Thank you very much for clarifying that. That's always the key, isn't it? Who should go? So just Ms. Cody, Commissioner Payton, Commissioner Kimball, and myself. Okay.
Excuse me, Chair Chan, also the court reporter should
And
go.
the court reporter, very important. Thank you.
And Tom too.
Takes a village.
And
Not
Tom.
Tom, because he's on one side and
Okay.
fighting from his position and Mr. Lasota's position on behalf of his client. So Commissioner Payton, do you mind making the motion for us?
I would like to make a motion that we go into executive session to discuss the legal aspects of this issue.
Thank you. Do I have a second?
Commissioner Kimball, second.
Okay, great. Let's go ahead and vote. Commissioner Kimball, how do you vote?
Aye.
Okay. Commissioner Payton?
Aye.
I vote aye as well. So by 3 ayes and 0 nays, we'll go ahead and go into executive session with those we've mentioned prior. And I think Ms. Herring can just move us over there. There we go. Click on the join button. think everybody is coming back. Ms. Cody, I'm glad you made it back. So that was your first time, I think, using the breakout room in Zoom. So, okay. And we'll go back into the meeting now. Are we all set? Tom, set or, oops, I think you're on mute.
We need to, what? I don't know. Tim, are you back or are you?
Uh-oh. Oh yeah, I see Tim, but
I don't see him. Should we call him? Let me see if we still have his.
I'm not too sure. Let him know. I know that was a pretty quick.
Hang on a second. Let me see if I have.
Oh, there he is. There's Tim.
Oh, okay.
Okay. Real quick, I had some legal questions that I wanted some clarification on, obviously. And I know that the next agenda item is discussion on, the lawsuit. And I don't want to hold things up, but I'll just be real frank. I'm having a little bit of, I want to say one thing. Tom is a brilliant lawyer, and that's why I generally defer, or not defer, but I like to take his recommendations and let him move on them, because I feel like he is, Tom, you're one of the most knowledgeable election lawyers I know. The one thing that is giving me a little heartburn about this, and I hate to frustrate you with this, but is applying campaign finance law to a business. And I understand why that's where you arrived. And I don't personally want to stop you from investigating it, though. And I'm leaning towards, if we can table this, is that something possible to do and hold it over until the next meeting? Or do we have to take action of some sort today?
For me, that's a question for Ms. Cody, not for me. I'm
Okay.
sorry.
Ms. Cody, I'm sorry. And I know I didn't really give you any time to research that. And if the other commissioners want to chime in, if you have strong.
From a practical perspective, I have no problem with that, but I don't think I'm the
Okay.
advisor in any way on that. That's my advocacy position.
And Ms. Cody, if you need to take time, I can just ask the other commissioners if they have strong feelings one way or the other. Do you guys want to take a vote today, or if we can table it?
I would, this is Gail and Peyton. I would like the other commissioners to be involved as well. I mean, they're both lawyers,
Yeah.
so that would, I think, give us even more perspectives.
Yeah. Ms. Cody?
Chairwoman Chan, to answer your question, I found nothing in your rules that would prohibit tabling this matter until your next meeting to take a vote on whether to proceed with the investigation. So that would be an option that is available to you. I did not find anything in your rules that would prohibit that.
Okay. And Commissioner Kimball, did you want to weigh in?
Yeah, I would be opposed to tabling it. This is not the final decision. This is just asking us whether we're going to empower Tom to investigate further. I don't know that tabling it is. I don't understand why we would table it. I can understand that it would be helpful to have the full commission here when we make a decision. But at this point, I see no reason to delay moving ahead and empowering Tom to conduct a further investigation.
Okay, I appreciate that input. I think I'm just of a comfort level similar to what Mr. Payton stated, that, and I don't want to stymie Tom's work either. But I really feel strongly that this is something I guess like a few more minds to weigh in on the commission, have some more discussion about, because it does feel like a watershed as far as, kind of attributing the requirement to file as a committee for a business that is, consulting. And And I don't know that we can separate that from the other issues. So, and Tom, yeah, okay. So I'm going to use my chairman gavel to hold on to this. I hope everyone can forgive me.
Madam Chairwoman, I believe that because it is an agendized item that you would need to make, or someone would need to make a motion, it would need to be seconded, and then there would need to be a vote. So you would need majority vote to continue it to the next meeting.
All right, I don't know if we'll get a second on that, but can I have a motion to hold it over to the next meeting?
This is Commissioner Payton. I would make a motion that we table this till the next meeting, the next commission meeting.
Okay, thank you. I don't know if Mr. Kimball doesn't want to be the second, how do we handle that?
Because there's only 3 committee members present today, you as chair could be the second in this situation based on the rule of impossibility. You have to be able to conduct.
Okay,
you can second.
Okay. Mr. Kimball, okay, I'll go ahead and second this, not make Mr. Kimball do something that he opposes. And with that, we'll take a vote to table it. Commissioner Kimball, how do you vote?
No.
Commissioner Payton?
Aye.
I vote aye as well. So by a vote of 2 ayes and 1 nay, we will move this over for the next committee meeting. And thank you everyone for that. And with that, we will move to agenda item 6. And let's see, discussion and possible action on the Power of Fives versus Clean Elections Commission. It relates to a lawsuit filed by the Power of Fives against the commission, and Tom can fill us in on the details.
I will. I'm sorry, Madam Chair, Commissioners. I will fill you in as best as possible. I think it was on October, I want to say 13th, but then there was an amended complaint filed on like the 22nd. This first amended complaint from the Power of Fives, it basically says 3 things. It says that it challenges the rule, Rule 110, that says basically that you can't take on obligation beyond cash on hand. It says that that's not a reasonable rule. It says that the commission doesn't have, and then a lot of stuff's about what we already heard with respect to in the other matter. And so I don't know how to avoid. There's crossover that's unavoidable. We don't have the other claim is basically we don't have the authority to look at stuff. That's the upshot. We won't have a responsive pleading due in that matter until I think close to Thanksgiving. So November, because there's not at this point a preliminary injunction, TRO, any of those things. So, and that is it. As you can imagine from the other discussion, I don't know who gets to decide what we do with this lawsuit. We would generally, left to our own devices, be inclined to defend it. Because we don't want to, we would not in this posture concede that the commission doesn't have the authority to do the things that we are recommending that you in fact authorize. We also don't believe that the rule in question is open to any real question. So, that's the staff view. The state of Arizona is also a party. I don't know who represents the state of Arizona, if anybody. I think Kara May. And I don't know if we get a call on this or the state of Arizona does. I just don't know.
Did that change with any of the legislation, or did that go away?
It depends on if you talk to the Attorney General's office, and I'm speaking for myself here, not for Kara. The Attorney General's office views itself as the representative of a state independent of its clients. The law changed to try to allow the Attorney General to settle cases that the secretary was named nominally and really has nothing to do, is only a codification of the Attorney General's view over the last 6 years. I'm not privy to how the Attorney General has resolved the state versus commission issue in this matter. I just don't know. And I also and this is a practical question, and I don't know who the right person to ask this is because I literally don't know the answer. I just don't know what and how where we are affects the responsiveness of the pleading. So, in other words, based on today, it's not at all clear to me that the commission would file a pleading to have this to defend this case because the commission has a decision in front of it that relates to it. So so those are all issues I'm sort of we just haven't fleshed out yet, and so I guess what I'm trying to say is I would ordinarily be saying we think we should do X, Y, and Z, or Kara might advise us in executive session about whatever she thinks we ought to do. I'm happy to do that. I just don't know how to parse out the different factors in terms of who gets to decide, what the timing of decisions is. I don't know any of those answers.
Well, maybe
Kara may have. I'm sort of inviting Kara to see if there's any of those blanks I can. Some of those she may be able to fill out some of those blanks. I'm just a little. I don't want to misstate or go too far. Is what I'm trying to say. I don't want to say we should do X or we should do Y or any of those things because I don't feel like that's the appropriate way to talk about this.
Okay, Kara.
Tom was right about the response deadline. It's been moved out to November 23rd.
Do we need to have another commission meeting where we can all 5 of us be here for the tabled item?
I think that would be the best call, and the sooner
Let's
the better. Like
next week.
For not only so that we can flesh out a legal strategy for dealing with this case, and I can talk to you about the alternatives, the legal alternatives, but I wouldn't want to do that in open session.
Okay, well, perhaps we can go into executive session. If the other members.
You look like you have a.
I don't have any. I have no opinion. That's fine. I looked like I was going to say something, but I wasn't. There were no thoughts there when I opened my mouth. Just my mouth opened.
So do we need to talk about this right now? Do we want to have another do-over next week when more commissioners can be here, perhaps?
This is Commissioner Caden. Oh, go ahead.
Madam Chair, this is Commissioner Kimball. Just for your scheduling information, I am unavailable from November 4th through November 20th.
All right.
And Chair, sorry to interrupt, but there are other commissioners that have several conflicts in November, so we technically don't have enough to pull than what we have today for our meeting. It may be challenging to pull at least 4.
Madam Chair, if I may.
Yeah.
Madam Chair, Kara, do you think that for purposes of discussing deadlines associated with the lawsuit that we may need to move, would that be a discussion in executive session or here?
Which deadlines?
Well, okay, so the question I have is, and I think that would resolve all of this, is if we ask the Power Fives for another extension of responsive pleading that gets us past this particular.
That's not happening. I mean, we can ask them, but I'm just going to
well then
be frank that I don't think that we will get another extension.
Okay, well then I'll be honest with you, Madam Chair. My opinion is we need a strategy at least to get us through this, and we should discuss it now.
Okay, so in executive session.
Yeah.
Okay. Can I get a motion to go into executive session? We need all the commissioners, Kara, Tom, Mike,
and Kyle.
I'm sorry,
And Kyle
Kyle.
Arias.
and Kyle, okay, and the court reporter.
And the
Um,
court.
Okay, so can I get a motion to go into executive session?
This is Commissioner Payton. I would like to make a motion that we go into executive session to talk about our strategy for this lawsuit.
Thank you. Do I have a second?
Commissioner Kimball, second.
Thank you. All right, let's vote. Commissioner Kimball, how do you vote?
Aye.
Commissioner Payton?
Aye.
I vote aye as well. And by a vote of 3-0, we will go into executive session to discuss this item. All right. See if we're all back. We have the court reporter, most important component for a meeting.
I'm here.
All
I'm
right,
ready.
excellent. Looks like we are all back, and I think we can just move on to item 7, public comment. So this is the time for consideration of comments and suggestions from the public. Any action taken as a result of public comment will be limited to directing staff to study the matter or rescheduling the matter for further consideration and decision at a later date, or responding to criticism. Does any member of the public wish to make comments at this time?
Can I make a comment?
Certainly, Mr. Sloan.
I would just encourage the commission to defend themselves and the validity of whether or not the rules that are applied currently, which are understood by the Power of Fives in their current application, otherwise this lawsuit wouldn't be needed, were enforced. I hope that the commission, I understand that there are going to be some scheduling conflicts moving forward, would reconsider whether or not an investigation is warranted into Mr. Branch and the Power of Fives, irregardless of the whether or not they need to be a political finance committee, but more importantly, to the point of whether or not their contract and their practices comply with the clean elections rules and laws as they're administered currently.
Thank you. Thank you, Mr. Sloan.
Thank
Yes,
you.
I see Rivko. Hi, Rivko.
Good morning, everybody. My name is Rivko Knox. I'm a longtime resident of the city of Phoenix, Arizona voter. And I just wanted to make a personal comment, which is that I remain very distressed by the fact that there have been no new appointments to the commission. It is my understanding that the commission meeting was moved from yesterday to today. Thursdays are the normal meeting day because it was not a quorum. And now I've been listening to the discussion, which was very interesting. I'm not sure I get all the legal implications there, but fascinating discussion about having to schedule another meeting and the difficulties involved in doing that. I do not have any answers, but I do find it very concerning because obviously one way to more or less neuter an agency is to not appoint new people. And therefore, that has happened, I believe, on the elections commission, the U.S. Elections Assistance Commission, and a few other commissions where new appointments are not made. And in essence, the body cannot take action. So I don't have any recommendations. I did years ago. And I know when I was here representing the league did submit a letter or two. And I realize obviously this is an upcoming election cycle, which has really started already. And people are very concerned with campaigns. But it's such a significant barrier to the commission doing its constitutionally required actions. And I don't know if anybody else has the authority to reach out. I guess I do as a private citizen, but I just wanted to note it for the record that it is very concerning to me. And I'm going to mute myself and close my camera. By the way, these represent the fact that I'm on so many Zoom calls. My husband got sick of listening to everybody else talk. So now I can hear you, but he doesn't. And don't take that personally. So thank you very much. And I appreciate your hearing my comment. And I continue to enjoy and plan to attend future meetings.
Thank you so much, Rivko. It's always such a pleasure to see you at our meetings. You're our most enthusiastic member of the public. And just full disclosure, it was actually my own fault. I asked whether we could reschedule the meeting because I had a field trip that my son was on yesterday. It was bad timing after we had all committed to our usual Thursday. That was entirely on me. But I will say you are correct. I am the only member who's still in my current term, and everybody else is just serving through their own grace, which I want to say thank you to the commissioners for, because they all have lives, very busy lives. And the fact that they're continuing to serve 5 years, some of them after their term expired, is incredible. And I certainly appreciate it very much. But, you know, I've seen in the news that we are not the only commission, sadly, that is in this situation. And it just seems that it only gets the attention of the governor's office when something makes the news, a scandal. And that's my own editorializing. I will say that we are very fortunate that we have wonderful commissioners. I'm not trying to give myself any props, but to the other 4 commissioners. So the fact that we don't have any new appointments is really not a detriment to the public so much. I would like to say more of a detriment to the members that deserve to be able to move on in their own lives. You know, but they're giving up their time continually for this, their dedication to elections in Arizona. So thank you. Sorry to editorialize. Anyone else wish to add anything? Okay. I'm not sure if I read the part about sending comments to the commission by mail or email, but you can do that at ccec@azcleanelections.gov. And with that, we can move on to item 8, which is adjournment. So at this time, I would entertain a motion to adjourn.
Madam Chair,
Commissioner Kimball?
I move we adjourn.
All right, thank you. Do I have a second?
This is Commissioner Payton, second it.
All right. Commissioner Kimball, how do you vote?
Aye.
Commissioner Payton, how do you vote?
Aye.
I vote aye as well. By a motion of, by a vote of 3-0, we have adjourned the meeting, and we will see you all next time. Thank you.